Hi everyone, this is Bhumika and Indulia. We are back with yet another episode of SCC Online Weekly Rewind. In this episode, we will discuss all the important updates such as Amazon dispute, important High Court rulings and some important legislation updates. So stay tuned till the end of the episode. In today's top story, we have brought before you the major setback to Amazon. While deciding the instant appeal filed by Amazon.com, challenging the order passed by the Competition Commission of India, dated 17/12/2021, wherein the CCI had imposed a penalty of 200 crore upon Amazon due to their failure to notify combination in terms of the obligation cast under Section 6 Clause 2 of the Competition Act. The bench, comprising of Justice M. Venugopal and Dr. Ashok Kumar Mishra, in a 300-page deliberation, upheld the decision taken by the CCI to impose such a penalty. The tribunal held that the Amazon did not make full, whole, fair, forthright and frank disclosure of relevant materials and had furnished only limited details pertaining to its acquiring strategic rights and interests over FRL and executing commercial contracts among itself and FRL concerning the ambit and purpose of combination. Therefore, the penalty imposed is justified. Amazon was directed to furnish the penalty within 45 days from the date of NCLT's decision. Moving on to the Supreme Court. In a significant ruling regarding better evaluation of possibility for the accused to be reformed, the Supreme Court has framed practical guidelines for the courts to adopt and implement for conviction of offences that carry the possibility of the death sentence. The court opined that a recent trend to call for a probation officer's report is in fact a desperate attempt by the courts at the appellate stage to obtain information on the accused. However, this too is too little too late and only offers a peek into the circumstances of the accused after conviction. Therefore, the court made it mandatory for trial courts to call for a psychiatric and psychological evaluation reports of the accused before awarding capital punishment. The court observed that implicit in this shift is the understanding that the criminal is not a product of their own decision, but also a product of the state and the society's failing, which is what entitles the accused to a chance of reformation. Explaining the law on vicarious liability under the Negotiable Instruments Act 1881, the Supreme Court has held that while Section 141 of NI Act extends vicarious criminal liability to officers associated with the company or firm when one of the twin requirements of Section 141 has been satisfied, which persons then by deeming fiction is made vicariously liable and punished. Such vicarious liability arises only when the company or firm commits the offence as the primary or offender. In a family property dispute wherein the legitimacy of one of the contenders was questioned, the Supreme Court has held that if a man and a woman live together for long years as husband and wife, there would be a presumption in favor of wedlock, and since in the present case the defendants had failed to rebut the presumption in favor of marriage between the plaintiff's parents on account of their long cohabitation, he cannot be held to be an illegitimate son. Taking note of the alarming rise in the number of sexual offences being committed against the school children, the Kerala High Court issued directions to the Kerala Government and Central Board of Secondary Education to necessarily prescribe session classes in school curriculum on the provisions of Protection of Children from Sexual Offences Act 2012 as well as the amendments brought into Section 376 of IPC in 2013. In a significant relief to non-NLU law graduates seeking job opportunities in PSUs, the Kerala High Court declared that NTPC's notification for the recruitment of assistant law officers is discriminatory and violates Article 16 of the Constitution for confining the selection process only to CLAT PG 2021 candidates. The court expressed that there is no logical basis for the assumption that professionalism and competence is the fiefdom of only those passing from elite institution. Process now adopted is more like a walkover to the finals for the chosen few without competing in the preliminaries. The Delhi High Court deliberated on the correct reading of the Rule 18 and 22 of the Transplantation of the Human Organs and Tissues Rules 2014 and clarified that the rules did not contemplate nor mandated spousal consent. The only requirement was of an independent consent being confirmed by a person other than the beneficiary. It was held that in absence of the statutory mandate that spelled out consent of the spouse for organ donation to be required under the Act, the court cannot read same and thus the stand taken by the respondents was incorrect. The Allahabad High Court dismissed a special appeal which assailed the dismissal of a writ petition by a single judge holding the same as not maintainable. Expressing displeasure towards the approach of the principal of the institution, the court opined that they should have been immediately informed about the fact that the institution would be unable to provide admission to their ward in class 8 as a day scholar student, so that such student could get his admission in any other institution for receiving a proper education, in as much as to receive proper education is a fundamental right enshrined under Article 21A of the Constitution of India. Moving on to the Tribunals and Commissions. The NCLT bench decided that for the purpose of repayment of the principal amount, issuance of post-dated checks by corporate debtor cannot be taken as unqualified admission of debt because the presumptions drawn under Section 118 and 139 of the Negotiable Instruments Act are rebuttable presumptions. The central government passed the New Delhi International Arbitration Centre Terms and Conditions and the Salary and Allowances Payable to Chairperson and Full-Time Members Rules 2022. The New Delhi International Arbitration Centre is a body corporate made under Section 3 of the Act. In the centre, any retired judge of the Supreme Court or High Court is made a chairperson, whereas two eminent persons having substantial knowledge and experience in institutional arbitration, both domestic and international, are appointed as the full-time members. The central government has notified marine aids to navigation duties of Director General Rules 2022 in order to provide duties and functions of the Director General. The Government of India, through Ministry of Ports, Shipping and Waterways, shall be the controlling authority for the matters pertaining to marine aids to navigation, including vessel traffic services. The Insolvency and Bankruptcy Board of India notified the Insolvency and Bankruptcy Board of India Grievance and Complaint Handling Regulations Procedure Amendment Regulations 2022 in order to amend the 2017 regulations. A grievance or a complaint shall be filed with the board on its dedicated portal, that is www.ibbi.gov.in. The amendment modifies the period for the aggrieved and the service provider to submit the information and records from 15 days to 7 days. The time period in which the board must close the grievance has been modified from 45 days to 30 days. That's all from this week's episode of Weekly Rewind. Stay tuned to our next episode.